Hi there, this is Jonathan Ginsberg, and I'd like to talk to you today about bankruptcy for seniors. And we get a lot of calls from people, sometimes from the senior citizen, sometimes from an adult child, asking about bankruptcy. Usually what prompts the call or are the harassing phone calls, the collection calls by creditors to the seniors demanding money that they don't have. And of course, sometimes these the collection phone calls can get very, very aggressive, intrusive demands that post-dated checks be sent or demands of access to bank accounts and so forth. And it can be very frightening and it can be very upsetting to anybody really to get these type of calls, but especially to a senior. A lot of my clients who are seniors have never had significant debt problems, never been in this type of situation. All of a sudden, just because of either the lack of cost of living increase or decrease of return on assets, or for whatever reason, they now find themselves in a situation where they don't have the money to pay accrued credit card debt. Sometimes it can be $50,000, $60,000, $70,000 in credit card debt, and they're getting these phone calls. What do they do? So if you're in that situation, let me kind of give you some ideas about how I approach it. And obviously I'm a bankruptcy lawyer, although I think that bankruptcy certainly is a last resort, and sometimes it's really not necessary. So usually there's two different situations that I see. One is, and the easier one is, if you have no assets, and basically you're living in a rental place, or you have a house but it's completely subject to a mortgage, there's no equity in the house, you have no other source of income other than Social Security. In that case, you're essentially judgment proof, and basically what that means is that the collection lawyer, if they turn it over to a lawyer, they can sue you and they get a judgment against you. They can't do anything with that judgment because a civil judgment from a credit card company cannot go after or cannot attach Social Security money. They cannot levy against a bank account that has only Social Security money in it. They could put a lien on the house, but that lien doesn't do any good if you don't sell the house. And you cannot foreclose on a $5,000 lien. We can't foreclose on a $200,000 house. So if the only situation you've got is that you have no assets, no liquid assets, and all they can do is they can call you, basically what you can do, and I've done this many times, is write what's called a drop-dead letter. And basically what that means is I write the creditor, the collection agency, the credit card company, and say, look, my client is a senior. His or her only source of income is Social Security. Federal law says that you cannot levy on Social Security money. You cannot levy on a bank account with Social Security money. So there's really nothing you can do. You're not going to get paid. If the situation changes, my client wins a lottery, we'll talk. But other than that, just put this into uncollectible status and write it off. And believe it or not, I've had a lot of success with that. I've had a number of clients and I get a phone call or a letter back saying, we've decided to put this in uncollectible status, and never hear from them again. So if you have no assets, if you're not liquid at all, we can write this letter, I can write this letter, and I'd say 80% of the time makes everything kind of go away. Now I would tell you one thing that's really important, and that is if you have a bank account and your Social Security money goes in that, you don't want to put any other money in that account, because once it is commingled with other funds, it is subject to claim by creditors. So what you can do is there's something called a sub-account. If you go to your bank and you say, look, I want to put an account just for my Social Security money, they can do that at little or no fee, and then any other money you have in there, that's at risk. But if it's $400 or $500, it's not that big of a deal, but you don't want your Social Security money to be at risk. So if you have no assets, you have nothing liquid, no equity, nothing that can be easily liquidated, then a drop-dead letter in many cases makes it go away. No need to file bankruptcy. Sometimes people still do file bankruptcy just to get rid of the phone calls and put an end to it once and for all. And those bankruptcies are very simple. They go through very easily without any kind of problems. So if that's the situation, that's an easy situation. A little more difficult situation is one where I have a client who is asset rich but cash poor, meaning that he or she may have a paid-for house for $200,000 or $300,000, have Social Security, may have some fixed investments, some bonds, some interest coming off CDs, whatever, but nothing that's really that liquid. And there may be $20,000, $30,000, $40,000 in credit card debt. In those situations, bankruptcy is really not going to be appropriate either, because you can file Chapter 7, but you'd lose your assets, and that's not acceptable. Chapter 13 is not going to work because there's really there's no income to regular income to fund a Chapter 13 plan. So in those cases, what I tell people to do is, to the extent that we can write a drop-dead letter, that there's nothing liquid, we do that. Otherwise, I may refer that person to an asset protection attorney. You've got to be very, very careful about transferring assets out of your name, but there are some situations you can create a trust. That's really not my area of practice, but I can certainly recommend people, and you want to protect yourself as best you can. Sometimes we can work out payment plans. So there's always options. The key with those situations, so if you have assets but no income, the key is to get to an attorney early. Don't wait until you're sued, because when it's early on, when you start to realize there's going to be a problem, then you have a little flexibility to do things. Again, create a trust, spendthrift trust, things like that. But once a lawsuit's been filed, you have very little time, and you really have very little options as far as what to do. So I would tell you that if you're a senior, you're the caretaker or loved one of a senior who is facing some debt problems or sees some debt problems coming down the road, pick up the phone, call me, call another bankruptcy attorney. Let's talk through the options, so you have an idea of what's out there, what the possibilities are, so that you're not forced to make difficult decisions or give up things quickly without having time to really plan for it. So that's how I approach debt situations with my senior clients. And again, I'm very sympathetic to the fact that most of my clients who are senior citizens never in a million years thought they'd be talking to a bankruptcy lawyer, and I'm real sensitive to that, and I try to make it as straightforward and painless as possible. But there are times when talking to a bankruptcy lawyer like me can be very helpful in obtaining peace of mind, to make life more livable, to live with some dignity, and there's no reason to let a bill collector or collection lawsuit lawyer make life miserable for you when there are possibly options, but you won't know unless you pick up the phone and call me. So hope this has been helpful. Again, my name is Jonathan Ginsberg. You can reach my office at 770-393-4985, and I'm happy to help you, answer any questions you may have. And until next time, I'll talk to you soon.